now. So hopefully you know James Westbury. He is the GRMA claims manager for Georgia Municipal Association, but he's also an attorney and a legal expert specifically on a variety of topics, but does a lot of law enforcement liability related work for us prior to him coming to GMA. With that said, I'm going to allow James to take it over. So go ahead, James.
Thanks, Dan. I appreciate it. Good afternoon, everybody. It's my pleasure this afternoon to talk with you about First Amendment. Can you hear me, Dan?
Yes, we can hear you.
All right. It's my pleasure to present to you this afternoon about First Amendment issues that come up in the context of local government. Most of this is going to have to do with situations that law enforcement officers confront when you're dealing with people who are either protesting or videotaping or what have you. Some of this will deal with people that want to come into the city hall or your facilities and videotape, ask questions, do things that might be annoying and try to provoke you to engage in some kind of a response that may violate their rights. And what I'm going to do is walk you through some situations. We'll talk about tactics that are employed a lot of times, and I will try to explain the law to you and give you some strategies to help keep this from becoming a legal issue. And so the problem is the First Amendment auditor. And I've got a bug up here, the mosquito, and a lot of times if I'm in front of a group, I'll get people to, tell me, what is that? What is that? And it's a pest. These folks come around onto city or county property or somewhere out in the public and are videotaping or engaging in some kind of an expression, and they're pushing it right to the boundary. A lot of times it's expression plus something else, like disrupting somebody's place of business or engaging in some kind of speech that is right against the line of what you can get away with. It's really offensive to people. And then the public calls law enforcement and you're expected to come out and deal with this person. So that's kind of the problem. And what I'm going to do is give you some examples of that so that you can see it. And the more you see it, the more we talk about it, the more it'll make sense and the more it'll sink in. And ultimately, it's actually very easy to deal with this. You just got to resist the urge to let emotions take over and fall back on your training and professionalism, and you'll be able to de-escalate virtually all of these situations, and the problem will just go away. So let's walk through this. This is an example. It was one of the first ones I had to deal with. It's with one of our cities, the member city, the city of Kingsland. And the setup is, this is a situation where there's teenagers walking through a neighborhood, videotaping. People get concerned. They call the police, and a couple of officers come out just to check on the situation and see what's going on.
Hey guys, Radical here. Gonna present to you a video clip that was presented to us this morning on 1/22/19 by a pretty popular auditor, and thanks to him for bringing us the attention of Kingsland, Georgia. Now notice it says City of Royal Treatment. Roll the clip.
Yep. Because I can. It's my right. First Amendment. So, yes, sir. 166. Huntington Drive. Thank you. That's all the information I'm giving. Don't have to. Hey, you lay hands on me. This is live. Just let you. No, I don't. What am I being? What? Okay. Just. Oh, is it suspicious? Okay. Suspicious of what? Of what? No, you step closer to me. Honestly, I live at 166. You want to talk to anybody? You can talk to my family. I am not even old enough to talk to you. 17. Well, okay, you can't do nothing. No, you can't. You can't do anything. You can't do anything, sir. Okay, I understand they call, but suspicion is not a crime. Suspicion is not a crime. You have to tell me what I have done before you can even ID me. I know my rights. I know my rights. I don't care. Am I being detained? Am I being detained? Am I being detained? You answer me. You answer me. I get answered first. Yes, I do. I'm a citizen here. I'm the citizen. Am I being detained? Okay, thank you. That's all you had to answer. I don't have it with me. I don't drive. I don't have it with me. Don't have to give it. I do not have to give it. I am protected. Protected. You can crack your knuckles and touch me. I don't care. You touch me, you're going. You're both of y'all will be done. I will sue state. I'm not being hostile. I'm not being hostile. Well, you won't let me go home. That's being hostile. I am threatened. I feel threatened. Okay.
However, we got a call. We have a legal reason to be here about a new videotaping.
And that's crime. And that's no suspicion of. Okay, is that a crime? Suspicious is crime. Suspicion is a crime.
Okay, listen. Talk over me one more time.
You can't do anything.
We're gonna have some problems.
Okay. I don't care. All right, cool. And I'll be out tomorrow. Because guess what? Y'all have no right to take me anywhere. Thank you.
We got a call. Somebody called.
That doesn't matter. You don't talk to me like that.
You're pissing me off because you're not listening. We got a call. Somebody called saying you're filming walking on the street.
Okay, that's law.
Okay, we got a call, which gives us the right to identify you. And if you refuse to identify us,
Suspicion is not.
Because we got.
Why you go home? You go to my house and get it.
Because we got a legal right.
You go talk to my parents. I'll sit right here. Nope. Number 5. I ain't gonna say nothing. I ain't gonna say anything. Go ahead. Yes, sir. And you better go to 166 and tell them what happened.
You don't have to go to your parents. Yes, you do. You're 17-year-old and you're an adult.
Well, guess what? If you don't, the whole fucking city's getting lawsuit.
Okay, guys, well, there you go. But I want to show you something here. We have multiple entry-level police officer positions available.
All right, I'm not going to show you the whole thing, but you get the picture. Basically, you got this teenage kid who's been schooled in the law just a little bit, walking around this neighborhood, engaging in conduct that's not illegal, but is provocative. It gets people to call. It's suspicious. Police come out, try to talk to the guy, and he's there trying to get them to arrest him. And he starts popping off at them. He's obnoxious. They demand identification. You cannot just require somebody to produce identification unless they've engaged in criminal activity. You can request it, but they can walk away from you. We'll talk about that a bit more later. But, basically the police officers did exactly what he wanted them to do. This ended up getting posted on social media, and the city was bombarded with contacts from people. Their Facebook page was overloaded. They called us. We got our defense lawyer involved to mitigate the situation, had the charges dismissed, gave the kid his bond money back, tried to mitigate it so he was in custody as little time as possible, and also brought in crisis management. But I show you this because the officers involved, took the bait. They did exactly what the auditor wanted them to do. They fell into the trap. So what I'm trying to do today is to show you some examples and talk you through this so that when you come across one of these situations, or people within your command come across these situations, you can help them deal with the situation, because if you just leave them alone, they will go away. That's all you have to do. But the harder you push, the more they're going to push back, and it's going to escalate and turn into a situation where you know, you're going to be portrayed negatively on social media, on the internet. You may get a civil rights claim, and you know, it turns into a legal problem for your city or county. So let's just keep moving. Sorry. Hang on. Hang on, I'm having a little technical difficulty here. Here we go. This is Jeff Gray. This is the most prolific First Amendment auditor we deal with. This guy comes up not infrequently. The first time I had to deal with him was in July of 2019 in a clip that I'm going to show you in a few moments. If you do a quick search on the internet, on YouTube, you're going to find probably a dozen or more situations where he's gone around Georgia to different cities and counties and engaged in auditor activity. He actually lives down in Florida, and you'll get a good feel for this guy as we watch over the clips. I don't know what this guy's like personally. He sort of promotes himself as a First Amendment advocate, you know, a do-gooder. He's got if you go to, you know, Fox News online, they've got a little story about him, how he's helping protect, you know, civil rights. But I think he just gives police officers and other people in government a hard time and makes their jobs more difficult. But we have to deal with him infrequently. So I hope when you get to see this guy and see what he looks like and what he sounds like, you'll know who he is if you come across him, because I know some of you will come across him in doing your jobs. This is a situation down in Moultrie. This is on July 3rd, 2019. The setup is he has shown up right outside City Hall with a sign walking around that says F City Hall. People are getting upset. They're calling the police department, telling them, unless you go out and deal with this guy, we're going to deal with him. So the city manager and an officer goes out and deals with him, and this is how it transpires. Oh, shoot. Technical difficulties.
He came inside and asked, could we use it?
Tell you what, I'm not having any luck getting this clip to play, but the next one is playing. So I'm gonna just skip.
Is it embedded in that one? I don't see a.
It's it was posted off YouTube. I've got the link embedded in there, and typically it works. Just not having. A very easy time getting it to play. My other ones are playing though. Let me just, what happens is he ends up having a debate with the city manager about this offensive sign that he's got out there, and the city manager tells him, you're going to have to get a permit to go do that, and he says he doesn't want to get a permit, and the officer who you see there on the screen ends up calling her supervisor, and supervisor comes in there. Ultimately, the guy gets arrested. Similar situation to the Kingsland situation. He gets arrested. This ends up blowing up on social media. They call me 2 days later on July 5th, which is a Friday, because the city has been inundated with people complaining. And, you know, we send in the crisis manager, send in the defense lawyer, get the whole thing under control. And the city, the question I got was, you know, what do we do if he shows up back here again? And I told them, just give him water, just accommodate him. He will go on his way. So let's try another video clip. All right, this is Port Wentworth. This one looks like it is going to work.
He came inside and asked could we use the restroom.
Yeah.
He told him, yeah, you could go upstairs, but he didn't go.
Okay.
He just went on out the door, and now he's kind of in the house.
All right, I'll ask him.
So just sweetly ask him to just
Yeah.
float along.
Yes, ma'am. I'll take care of that for you.
Just stand in front of my seat, all to my sports on the deck. You just stand in front of my seat, all to my sports on the deck.
Well, I mean, so is there a reason why you want to stand here?
God put it in my heart to stand right here and spread the message. God bless the homeless.
I'm all for that. You're not doing anything wrong. You're not breaking any laws by any means.
Okay.
You're not breaking any laws. You're not in trouble.
Yeah, you said I'm not breaking any laws.
Well, no, technically he's not breaking any laws, but he's on city property, so they can ask him to leave.
Yes.
And that's what I told him. I said, you're not breaking any laws. The ladies don't feel comfortable with you standing out here. No, he was polite about it. And I said, well, you're not breaking any laws. But he said, listen, you're not breaking the law essentially by standing here with a sign. And so I said, look, you're not really breaking the law. I said, other than the fact that ladies don't want you sitting here in front of City Hall. Go ahead. Come up here to change the thermostat and drop off my direct deposit. And as I pull up, there's a guy walking up with a sign. And apparently he came in while I was upstairs to come and ask to use the bathroom. And he had like a homeless veteran sign, but he wasn't like pandering or asking for money, he's just holding the sign. So he comes in, use the bathroom, and then walks directly back out, doing use the bathroom, and then comes back around and stands in front of City Hall, just showing the sign. Normally not breaking any laws. The ladies up here didn't feel comfortable with him just standing up here, so they were asking me to ask him to leave. I'm like, all right, cool, it's city property, no problem. He says, look, man, you're not breaking the law. I said, but the ladies don't want you up here. So essentially, if you don't want to leave, I can trespass you and then make you leave the property. And so then I asked him for his identification because it kept going. He started playing the game, started recording the interaction, trying to draw it out. I told him, go ahead and give me your ID. And I asked for it several times. He wouldn't do it, so I arrested him for obstruction.
As many of you may remember, back in July of 2021, I was unlawfully arrested in the city of Port Wentworth, Georgia, while politely engaged in freedom of speech and freedom of religion while peacefully standing on a public sidewalk, also known as a traditional public forum, outside of the Port Wentworth, Georgia City Hall, only to be arrested by one of the dumbest cops I've ever encountered, Sergeant Heminger of the City of Port Wentworth Police Department, who was acting under the direction of one of the dumbest city employees I've ever encountered, Shanta Scarborough, City of Port Wentworth, Georgia. This arrest was as clear-cut, black and white, cut and dry a civil rights violation as you could possibly get. Yet more than a year later, the state of Georgia is actually pursuing prosecution against me for the bogus charge of obstruction, as you can see here in this document. In the State Court of Chatham County, State of Georgia, the State of Georgia versus Jeffrey Marcus Gray, defendant. Accusation, count 1, obstruction of an officer. On behalf of the people of the state of Georgia, the undersigned as prosecuting attorney for the county of Chatham and the state of Georgia does hereby charge and accuse Jeffrey Marcus Gray with the offense of obstruction of an officer for that said Jeffrey Marcus Gray in this county of Chatham and the state of Georgia on or about the 19th day of July 2021 did knowingly and willfully obstruct Officer Heminger, a law enforcement officer with the city of Port Wentworth, Georgia, in the lawful discharge of his official duties by failing to provide identification contrary to the laws of the state of Georgia, the good order, peace, and dignity thereof. Signed, Shalina Cook Jones, District Attorney, Eastern Judicial Circuit of the state of Georgia. Shalina Cook Jones, you big dummy. Yep, that's correct, folks. It seems that old Shalina Cook Jones here wants to establish new legal precedent by prosecuting and outlawing our First Amendment protected rights of freedom of speech, freedom of religion, and freedom of assembly.
He came inside and asked her to use the restroom.
Yeah.
He told him, yeah, you could go upstairs, but he didn't go.
Okay.
He just went on out the door. Now he's trying to hang out flying.
All right, I'll ask him.
So just sweetly ask him to just
Yeah.
float along.
Yes, ma'am. I'll take care of that for you.
And we're going to fast forward because the video is really long.
Reason why you want to stand here?
God put it in my heart to stand right here and spread the message. God bless the homeless.
I'm all for that. I'm all for you recording. I got no issue with that. Okay.
All right.
I got my body cam on. So
Okay.
I didn't know what that's for. I'm probably seeing it across the intersection. Anyways, so what I did was I called for a patrol unit because I'm actually working for the code enforcement section. Okay. I'm still a police officer. This is city property. Okay. You do have the right to spread your message anywhere you want, unless it's private property. Then they have a right to ask you to leave. They can't tell you turn your sign up or anything like that.
Right.
But that's the whole point of why I was out here talking to you. The lady didn't feel comfortable somebody just hanging out front of City Hall.
Okay.
And being that it's on city property, they have a right to ask you to leave. You can go stand on that corner. You can go stand anywhere it's not actual city property and do as you wish, brother, and spread the message. So that's all I'm saying. Okay. Now, if you refuse to leave, then it would be trespassing, and then you'd be in trouble. So I'm asking you nicely, it's just to relocate. That's all I'm asking you to do. You can go spread that message with love any way you want, other than city property right here. Exactly. You understand what I'm saying?
This is city property.
All this is City Hall. It's just city property.
All right. Am I being trespassed?
As of now, you are. Give me your ID. Now it's an investigation. I want your ID. No, give me your ID. You're not free to go now. Now you want to play the game. So give me your identification.
You're trespassing me already.
Give me that identification. You're going to jail.
Give me
your identification so I can identify you and I can trespass you. Then you can leave. I'm not going to ask you a third time.
If I get arrested, I'll lose my job.
I'm not trying to arrest you. I'm trying to get you to comply with me, and you're trying to refuse to do that. So listen to me carefully. I want your identification so I can identify you and trespass you. Sir?
What time do you suspect me?
You're failing to follow a lawful order, which is they've asked you to leave city property or asked me to ask you to leave. You're refusing to do so. Now I'm going to trespass you from the property because I asked you 3 times lastly to step off somewhere. No, now you wanted to refuse, so now I'm going to identify you and I can trespass you.
If I don't give you my ID, I'll go to jail.
That's exactly correct. You'll be arrested. You'll be fingerprinted and released. All I want is your identification. No, because not because of the sign, but because you failed to comply with my investigation, which was I asked you to leave nicely initially. You wanted to play the game with me. Now I'm playing the game with you.
Well,
Let me have your identification. Let me have your identification.
I said I was
Identification. I'm not gonna say it. Handcuffs. Turn around. Turn around. Let me see your sign. You put your phone in your pocket. All you can do is give me your ID, bud. What's so harm with that? You know the game because you want to say, am I being trespassed? You could have gave me your ID. I would have trespassed you and let you walk off, brother.
Yeah, you're telling me to leave. I would rather not leave.
No, you're playing the game with me is what you're doing.
If you're trespassing me, I'll leave.
I asked you to leave before that. You wanted to play the game and make me trespass you. Don't play dumb games, man. It's going to get you in trouble.
Don't turn it. Why are you
I'm putting it in your phone. I'm putting it in your...
You just stopped the recording.
It's all recorded right here. It's all recorded right here. I'm saving your battery.
Take my phone and start recording.
Sure, gladly. If that's what you want me to do, brother, I'll do that for you.
Thank you.
There you go.
Can you put it in my shirt pocket right here?
I'm going to put it in this pocket. It's going to fall out because it's an iPhone. I don't want to break it, dude. I don't have the money to replace your phone. You see how this easy to put it in? Here, officer, here's my ID. Now, I probably would have trespassed you because I asked you at least 5 to 6 times to step off the property. You said politely that you didn't want to do that. I didn't have a problem with that. I went back and asked the ladies, I said, what do you feel comfortable with? They said, no, I don't feel comfortable with staying out here because there's a bunch of ladies that work in here. Even though you're not being violent, they have a right to ask you to leave, partner. All you had to do is go step off to the next land property over there and you could spread the message of love all day. You understand what I'm saying? I wasn't trying to bust your chops, man. I'm just doing my job.
Everything silent.
Okay, you have that right. You have that right. The only thing you have to answer is name, date of birth, and about your current address. Is all that current on your license?
Yes, it is.
Okay. All right.
All right, I'll just stop it right there. You get a sense. Let me say just for information, this case actually, since the first time I gave this presentation in the spring, this case has actually been filed and is pending litigation against the officer involved. We are defending it, trying to resolve the case, but just a few things to point out. You know, on the videotape, and you are seeing this on videotape, any of these things are going to end up on social media, on YouTube or somewhere else, and you might get portrayed in a way that you don't want to be portrayed. So that's another reason to not take the bait. But as we go through it, you know, the officer says, you know, a dozen or so times, you're not violating the law. And then what he actually tries to arrest or tries to get him to leave for is trespassing on public property, which is really an oxymoron. You know, if he'd been on private property and been asked to leave, that would be one thing. But because he's literally out on the sidewalk in a public setting, engaging in expressive activity, that is protected under the First Amendment, and you cannot take action against him as a result of that. So the officer involved ended up in a situation where he let the guy push his buttons, arrested him. It's exactly what he wanted, and there we are in court. Okay, next example. This actually happened. Some of y'all been to the city of Madison. This happened in spring of this year. As you come through Main Street in Madison, near the square, there's a restaurant called the Chop House. And the guy who operates the Chop House, who is actually a veteran, called and complained because Mr. Gray had a sign that said "Pray for Homeless Veterans," and he was annoying everybody who tried to come into the restaurant. So it's always expression plus something else, and it goes right up to the line. So the officer gets the call, and I'm going to give you two vantage points here. One is from the hidden camera, and the other is from the officer's body cam, which is an open record, and they will request and put that up on social media too. So we'll start with the hidden camera.
Well, this is a public sidewalk. I have every right to be here, so I intend to stay. God put it in my heart to do this.
You can't bother people, and you can't be a vagrant on the street.
Okay, that's fine.
So we can move you, or we can take you to jail. I'm going to leave that up to you.
So I have what are my choices?
You can move, or you can go to jail for vagrants. Okay. I don't care.
Madison, Georgia, located right in between Atlanta, Macon, Augusta, and Athens, Georgia. The town of Madison is named in honor of founding father and America's fourth president, James Madison. James Madison is widely considered to be the primary author of our Constitution and the father to the Bill of Rights. Madison, Georgia should be the perfect place to peacefully engage in freedom of speech, freedom of religion, and freedom of assembly on a traditional public forum such as a sidewalk. God bless the homeless veterans.
He's hiding the camera. Fast forward here.
Hey, y'all. God bless the homeless vets. God bless the homeless veterans. Please pray for our homeless vets. Yes, sir.
I don't need you out in front of my restaurant, please, sir.
Is it your restaurant?
Yes, sir, it is.
God put it in my heart to stand here and do this.
You can go over there, you can go over there.
I'm sorry, I'm hard of hearing.
I said you can go over there, you go over there. You can't be in front of my restaurant and standing in front of people that are coming in and coming out.
Yeah, that's who I'm targeting with my message.
Yeah, you can't do that.
That's what I'm doing.
Okay, move away, please.
No. Not happening. God bless our homeless veterans. God bless our homeless vets. God bless our homeless veterans. I tell you, thank you very much for that, but I'm not homeless myself. I just like to come out in public and say God bless the homeless vets. But that is very kind of you. God bless you for that. God bless you.
All right, I'm gonna fast forward so you can see the interaction with the officer and extra points for anybody who can find the F-bomb in the presentation. Mr. God bless you.
Hey, y'all. God bless our homeless veterans. God bless homeless vets.
Here we go.
How you doing, sir? God bless homeless vets. God bless our homeless vets.
Hi, I'm Gary. Good to have here. This gentleman, unfortunately, he's bothered our guests coming in, coming out. He's already made 8 people walk away. Don't want to knock on our business. We go over there. I don't mind. So he can do what he wants to do. Thank you.
That's the deal, boss. I gotta move.
My name is Jeff. What's your name, Officer?
Mike.
Officer Mike. What's your last name? Oh, it's Maxwell. Okay. Well, this is a public sidewalk. I have every right to be here, so I intend to stay. God put it in my heart to do this.
You can't bother people. You can't be a vagrant on the street.
Okay, that's fine.
We can move you. We can take you to jail. I'm gonna leave that up to you.
So I have. What are my choices?
You can move, or you can go to jail for vapors.
Okay.
I don't care which.
Well, let me tell you this. This is freedom of religion,
Okay.
freedom of
You
speech.
can argue that in court if you want to go that route, but I'm not arguing with you. You can
And I-
leave and have a good day somewhere else, or you're going to come with me. Those are your two options.
And going with you would mean going to jail.
Yes.
Okay, I will leave under protest and under duress
Okay.
and under threat of arrest, right? You're threatening to arrest me if I
I'm
don't
telling
leave.
you to move, and you're not moving.
If I don't move, then what happens?
Then you go to jail.
I go to jail. All right.
Don't come back.
And don't come back, what does that mean?
Come back for harass people. That's what that means.
Did you see me harass anybody? Officer, don't tell me to get out of here. Who the fuck do you think you are? I'm acting a fool by standing on a public sidewalk saying God bless the homeless veterans. All that was on camera, by the way. This is freedom of speech. I'm gonna give you one last chance. One last chance. Freedom of speech, freedom of religion, freedom of assembly on public property. I'm sorry. So if I don't go, I'm going to jail. All right. Freedom of speech. Did you take an oath to honor me? And by go, you mean like leave the whole town? I'm not bugging anybody. That's hearsay. That's hearsay.
All right, so clearly y'all can see that he was standing out there harassing customers going in and out of the restaurant. The owner comes out and complains. He has 8 patrons whose business he loses, and the officer comes out and tries to deal with him.
Well, this is a public sidewalk. I have every right to be here, so I intend to stay. Up.
This, I'm just showing you because it's the officers. He's going to have the body cam. He's got the hidden camera here, but what these guys do is once they get the whole thing on tape, they'll do an open records request and get the officer's body cam, and they'll put this up as well. Sorry, this is the body cam slide.
How are you, sir? What's going on?
God bless homeless veterans.
What's that?
God bless the homeless veterans.
Thank you.
So what you can see is that's clearly the officer's body cam. I'm showing you this so you understand this guy is knowledgeable in First Amendment law. He knows which buttons to push with freedom of expression, freedom of religion, and they're knowledgeable about the Georgia Open Records Act. This is a situation that happened down in the town of Blackshear. Same fellow.
Yeah, just saying God bless homeless veterans. That's all.
You can do it.
Okay.
You just got to get a permit first to demonstrate.
Oh, really?
Any public property, you have to have a permit to demonstrate all that kind of stuff. It's kind of silly, but that's what the rules are.
Ah.
And we'd be glad to put you on an agenda so you can, but I don't make rules. I just enforce them. But you can, you can basically what you have to do is send a letter to the city saying what basically I just want to show my.
All right, so here the police chief comes out and he's having to deal with Mr. Gray and telling him that he needs to have a permit to stand outside and do that. Anytime you have a permit involved with somebody who's going to engage in expressive conduct out in a public area, that's a big red flag. Because what's going to happen if you get arrested or they get arrested, they're going to have a false arrest claim. They're also going to have a claim against the city or county for having an unconstitutional policy or ordinance. And what I'm showing you here is actually the lawsuit that Mr. Gray filed against the police chief in federal court. And these guys have a cookie cutter they use. As much as I love the University of Georgia, I don't like what the University of Georgia Law School is doing to enable these First Amendment auditors. They have a professor up there who teaches First Amendment, and she represents a lot of these people when they sue cities and counties around Georgia. I disagree with what they're doing, and I'm just showing you that just so you will know what's involved. I love the University of Georgia as much as anybody. I have a degree. Both my children have degrees, and I'm all about the Bulldogs, but I don't like suing public officers and employees who are trying to do their jobs. This is the second frequent flyer who I'm going to show you. This is a guy named Kenan Dunn. Now, I'll give it to Mr. Gray. He is actually more likable. He doesn't seem like a bad guy. He can be a little bit obnoxious, but Mr. Dunn just comes off as completely obnoxious. And what he does is goes around and hangs around in public areas, in City Hall or in a public building, and videotapes, makes people feel uncomfortable, pushes people's buttons, and pushes them to violate his rights. And I'm going to show you an example.
Well, you weren't barking orders. I don't know who you are. Well, that sucks. What's that? This is a public lobby, is it not? I need to worry about it, because if it's not, I need to get out of it. If it's a public lobby, I'm okay to be here. Okay. Then why is she calling the police? Oh, she walked off. You had something to say just a second ago. Man. Did she call the police? Well, like I said, she's a city admin. Is that what she said she was? Do you work here? Do you work here? Okay, so are you going to be an ass? Are you going to answer the question? Well, may I speak with the city admin then, please? May I speak with the city admin, please? City clerk. May I speak with the city clerk, please? All right, guys.
Yes, sir. You called me? Okay, what's the problem? Oh, I know who this gentleman is. He's been traveling from city to city. Yes, sir. Can we help you?
Who you?
I was calling you.
Officer Clown?
Town.
Town, okay.
Yes, sir.
And you?
I'm Chief Jackson.
Chief Jackson. Nice
Yes,
to meet
sir.
you, Chief.
Chief, yeah. I told you, my name is Chief Jackson. Who am I speaking with?
Speaking with me, sir.
Okay, who is sir now?
You can call me sir for now.
I'm not gonna call you, sir. I need to know a name.
That's
You asked
okay.
me who I was.
Yeah.
All right.
Well, I didn't call you. They called you.
Yeah, but they got a problem, so
I don't know. Did you discuss that with them?
you say you got a problem, Miss P? You say you got a problem with him?
Well, you just want me in, and me and them was up to the phone, I asked about him, and he said, not right now, and then you asked him who he was,
Uh-huh.
and he just taking pictures,
Oh, okay.
and if you want to know who he was, you know, you trying to figure out what's going on with this.
Oh, okay.
And Chief, is that against the law?
It's all depending on if they say you bothered them really. If you ain't bothered them, you should finish up and then you
No, it's not. It's not. It's not Smith personally coming, sir. Come on, Chief.
Are you finished?
Come on, Chief. No, I just got here. I've been here for less than 30 seconds, and she called the police. I was over here taking photographs over here with this.
Oh, okay. What you looking for? Maybe we can help.
I just want to see what information was available to the public.
To the public.
Yeah, this
Okay.
is information right here.
After you did open book request?
No, you see what you have readily available to the public.
Oh,
You got
okay.
financials right here, financial assessments,
All right.
public records here,
Whatever you need, you do an open book request. We try to grant it for you. Okay.
open records request, yes.
Yes, sir.
Mhm.
All right. And then once you do this, we'll ask you to move on. Okay.
Ask me we're going where.
You finish what you're doing. Okay, because this is where they pay the bills at. So,
Okay, well, nobody's been in here.
okay. All right. We'll give you a little while to do that, and then you should be able to move on.
When I get done, I'll be happy to move on to you.
Now, how long ain't gonna give you all day now?
Well, it takes as long as it takes, don't it, Chief?
No, because you
How long?
hadn't did no open book request.
I don't have to do it open. Well, Chief, how much time are you trying to tell me I have?
Let's see, you've been here, how long you been here, Ms. P? Oh, okay. Soon as he started interfering with the people coming in and doing their business, then he might be.
So you're trying to make up something
No,
to run me out. There's nobody in here, and if I'm conducting,
I said,
come on, Chief, Chief, you already know who I am and what I do.
already know who you are.
So why are you trying to start problems then, Chief?
I don't know about, let me say here.
I told you I'm in here doing, you know what I'm
I'm
doing.
not gonna let you stay here all day with
So-
that camera. I'm not gonna do that, because people got
Don't-
personal information in here, and you don't have a right to give people personal information. You don't wanna tell me who you are, and I'm supposed to give you everything you request, and you don't say anything.
That's how it works, Chief.
No, it don't.
Yes, it is, Chief.
We're gonna go around the block, we're gonna go around, we're gonna give you enough time to do what you're gonna do, and then we'll ask you to move on, please.
Well, I will move on when I get finished doing what I'm doing, when I finish conducting my business, Chief.
It ain't gonna be all day, now, I'm telling you, it's not gonna be all day. I've been sitting watching you on Facebook, going to the police department.
You ain't seen me on Facebook.
I see you on Facebook, I see you at Fort Valley Police Department, I see you at different departments. So we're not gonna let you just come in and take over Marshallville. You do what you gotta do.
You haven't seen me on Facebook. And what do you mean take over Marshallville?
You're gonna come in and try to do what you're gonna do, wanna run over people, that's what you wanna do.
How am I running over anybody? I come in here and take photographs of what you have in public
Then we let
and
you do
nothing
that.
said,
We let you
and then
do
I
that.
leave. You're not letting me do anything. I came in here and did that.
Fast forward this in the interest of time, so you can see what transpires.
To my rights. I'm letting you know that now. I came here to take photographs, which I've already told you.
We let you take photographs.
Sir, I came also to look at public information. You got financial, how long does it take to look through financial records, sir?
I actually you to tell me who you are. I don't know.
I don't have to tell you anything, Chief.
I actually leave. This
Chief.
is my third time asking you to leave.
You cannot run me out of here. I haven't broken any laws, sir. You making up a false charge of disorderly conduct when I'm just sitting there being quiet. I'm looking because I was taking photographs, which is protected. This
A lot of personal information is
There is-
shared around it. And I'm supposed to just give you the opportunity to get anybody's information.
sir,
Because you
I came to take photographs of what you have publicly accessible. I can't hear you. I'm hard of hearing.
are you gonna leave?
You got this recording, sir?
Are you gonna leave?
Yeah, I got it.
Are you gonna leave?
If you give me a lawful order that I have to leave, I will leave. But if you're asking me, then no, Chief, because that's not a lawful
You're
order.
not gonna leave, inflation. under arrest for disorderly conduct. Here in Marshall.
You're gonna place me under arrest?
Under arrest for disorderly conduct.
No.
You refuse to identify yourself?
Because that's not, I won't have to, because
Okay. We didn't ask you 3 times to leave.
I said I will leave. If you're telling me I have to leave, I will leave.
Well,
For the record.
you leave.
But you're asking or telling. If you're telling me, I will go. If you're asking, I don't have to.
I'm asking you to leave.
Sir, I'm gonna walk down this way to disengage from you, Chief, and give you a second to think what's going on here. Yeah. Well, so you're gonna make a disorderly conduct.
Let's tell you, we didn't ask them. You're
I'm starting with
disorderly conduct.
Okay. Hey guys, Marshallville, Georgia.
Yeah.
Can we just walk down there? Because I got.
No.
All right, y'all see what happens. He gets arrested. A couple things I'd point out. He comes into City Hall. He's being disruptive, but he's not doing anything illegal. He asks for information, and under the Open Records Act, it does not have to be a written request. He's very knowledgeable about that. He comes in pushing buttons, making the chief uncomfortable, taking the chief to, the limits of what he's comfortable dealing with. The chief ends up arresting him without having a crime. And it's significant because if an officer does that, at least you might have a qualified immunity argument, and that's just liability for the officer individually. When it's the chief who's the policymaker for a jurisdiction, that also creates liability for the city, and the city or county, unlike an individual officer, does not have a qualified immunity defense. So I'll walk you through. This is the aftermath of this situation.
Hey, James, I got a question here.
Okay.
Just out of curiosity, do any of these individuals ever come away with decent cash settlements from suing these local municipalities? I'm just trying to understand, aside from the YouTube views and potential virality, why these individuals would waste so many people's time.
That's a great question, Dan, and it's a good segue into the next part of this story. He ended up filing suit against the city and the county for unlawfully detaining him and arresting him, and he ended up hiring this gentleman whose picture is on the screen. This is Jerry Weber. I've been litigating with Jerry Weber for over 20 years. He was the legal director of the ACLU in Atlanta, I think the ACLU of Georgia, and he has gone around, and now he's in private practice, and he represents these people. And he ended up suing the city and the county. And the problem is, even if it's the most obnoxious, unsympathetic plaintiff in the world, if they can establish a violation of their constitutional rights, they recover all of their attorney's fees. So we ended up litigating with this case briefly to the point where the motion to dismiss was denied. And by the time you realize you've got a liability problem on your hands, you've got pretty significant attorney's fees involved. So he was able to get a combined settlement of $95,000 from the city and the county. That's exactly why they go around and do this. They also get money for the number of hits they get on their Facebook post or their YouTube post. So that's how they make money out of this. Mr. Dunn has had a couple of lawsuits. Mr. Gray has had several lawsuits. The group that represents Mr. Gray, from what I can tell, they're less interested in the financial component of it, but they too require payment of money in settlement to get rid of the claims. A lot of times they'll also request that or as part of the settlement, the city will have to do some training with city employees to help keep situations from this happening. But that's a great question. They do it for the money, and the reason you pay the money is because the attorney fee component, because it gets so expensive. And like the plaintiff lawyers who represent people in these cases, they get an hourly rate that's typically more of a premium rate. Like for most of our defense lawyers in the GRMA program, we would pay somewhere around $200 an hour, and these are experts that handle these kind of cases all the time. When the plaintiffs come in, the judge recognizes there's a contingent aspect to the fee, and sometimes they might get $450 or $500 an hour. So you don't have to litigate a case very long until you run into a lot of money. I had another city where we had some community activists where the city actually banned people from City Hall, and Jerry Weber represented several of these people against the city, and we paid a pretty significant settlement because it was just not defensible. You can't just kick people off public property like that who haven't engaged in a violation of the law that's not related to expression. Good question. That rolls us right into Section 1983. This is the federal statute that most of you have heard about that is invoked by plaintiffs to bring federal lawsuits if there's been a violation of somebody's constitutional rights. In the context we're talking about, it would typically be a violation of their First Amendment rights and then their Fourth Amendment rights against unreasonable searches and seizures. If you arrest somebody without probable cause that they've actually committed a crime, that's a Fourth Amendment violation. You can bring one of these lawsuits against the local government if it relates to an unconstitutional policy or custom, such as having a permit requirement on the books. Cities and counties do not have sovereign immunity on these claims. If the individual is sued, a lot of these rights we're talking about are clearly established, so you will not be able to establish qualified immunity as defense, and the plaintiff will be able to recover attorney's fees and potentially punitive damages. Both the GRMA and IRMA programs would provide you a defense on this kind of claim, but it's going to impact the loss history of the city or county involved. Plus, it's going to tie up a lot of your time, and you may end up being portrayed negatively by one of these auditors on the internet. The attorney's fees component, as I mentioned a few moments ago, is the aspect of these cases that require us to roll over a lot of times and settle them, because if there's a clear First Amendment violation, we're just digging a bigger hole if we continue to litigate the case, because we're having to pay both our attorney and ultimately pay the attorney on the other side. The first couple of situations that I showed you involving Kingsland and Moultrie were situations where, like, the same day we got defense counsel involved, made sure that nobody was maintaining custody, gave anybody their money back, so that the likelihood of having to go forward with a civil lawsuit was very minimal. But the attorney's fee aspect is what makes these cases very much in the city or county's interest to get resolved early so that the claim doesn't spiral out of control. The goal here, as this slide illustrates, is to keep the city, or the county for that matter, off the hook. You don't want the city or county or you to be that big fish hanging up there. So let's talk about some law that applies in this area. The thing we're talking about, of course, is the First Amendment to the U.S. Constitution, which says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or the press or the right of people peaceably to assemble and to petition the government for redress of grievances. What we're talking about primarily is freedom of speech, freedom of the press, and the right to assemble. On Mr. Gray's situation where he wants to pray for the homeless veterans, he's also added another lever here by invoking religion. So this is what we're talking about. And any of these rights we're talking about that are explicitly set out in the Bill of Rights are typically going to be fundamental rights that are going to receive the most protection. Now, in terms of the most protection for freedom of expression, you're going to have that in a traditional public forum. That's typically going to be like a public street or sidewalk or a city park, basically any place you've got a right to be. In a limited public forum, you're going to have slightly less freedom. You're not going to be able to disrupt the council session. Basically, you're going to have as much right to be there and express yourself as anybody else. You have a right to be there and assemble. You have a right to sign up, and you cannot be discriminated against based on the content of the message. Next would be a designated public forum. This would be like where you have a university that may have a hall where a group can meet or have some kind of a forum. And in that situation, you can't just come in there and disrupt, but you have a right to be there. You have a right to, listen, but you don't have a right to disrupt it. And then you have the least protection in non-public areas, which would be in the part of the public forum which is not open to the public, maybe behind the door outside the public area. When you go through the door, you have the areas where people work, or you might have a public school. The public can't just go into a public school, so you don't have a right to be there. If you have a right to be there, you have a right typically to express yourself as long as you're not being disruptive, like to public order. On a sidewalk, you can say whatever you want to, with very limited exceptions. And anywhere you have a right to be, you're going to have the right to videotape. Again, this is just a summary. In public areas, you're going to have broad rights to free expression, free speech. The government generally cannot interfere at all. In non-public areas, rights are more limited, and restrictions are permitted if they're reasonable and viewpoint neutral. So if you're going to let if you have a public hall and you let, the Democrats come in and use it for their rally, and then the Republicans want to use it the next week, you can't, let one group and not the other. You have to treat everyone equally.
Hey, James, I got a question.
Sure.
If somebody comes into City Hall and there's an open door to the hallway, but if it has an employees only sign, what would be the best approach to removing them to the public areas if they enter that hallway?
If that's a good question. If somebody goes into an employee only area like that that's open, but they still have access, you would be within your rights to come in and ask them to move themselves back to the area that's open to the general public. If they continue to stay in the non-public area, then they are trespassing, and that would be a separate crime, and you could call the police and have them, arrested for trespassing. But the best approach would be to try to get them to move out of the way. Now, any of these interactions, if you're going to do something like that, you may not have time, but it would be great if you had it on videotape, because you can record just like they can record. So videotape tends to cut through any disagreements about what, one person says happened versus what another person did. So if you could videotape it, it would be better. But you can remove somebody from an area that they don't have a right to be, and if they continue to persist, they're trespassing. And that takes us to videotaping. In the 11th Circuit, there's a case holding that persons have a First Amendment right to videotape the police, subject to time, place, and manner restrictions. There's this Smith versus Curry case cited there, and First Amendment affords the broadest protection to political expression and protects the rights of speech and petition to redress and to photograph police activities. And just to highlight the importance of this right, I'm just going to say two words: George Floyd. Think about George Floyd. The whole reason that George Floyd captured the attention of a nation is because you had bystanders videotaping police misconduct. So that's this is a right that is protected by the First Amendment. And if you look at the George Floyd situation, you understand why this is such an important protected right. Public meetings. Public meetings are limited public fora at which the government may restrict access by content neutral conditions for time, place, and manner of access, but it must be narrowly tailored to serve a significant interest. For example, if you have, say, a public meeting of a city or county commission or a school board meeting, you can require people who want to speak up to sign up, on a sheet and limit their time. And you cannot, just allow people who are for or against, something to speak. You've got to have a content neutral policy. You cannot have a total ban on recording. There's a federal district court out of Northern District, Georgia, that held that a total ban on recording was not narrowly tailored to serve a city's interest in conducting orderly, efficient meetings. So again, that's a First Amendment violation, and a total ban on public recording public meetings is not going to be sustained in the courts.
James, got a couple other questions.
Okay.
How does this apply to fire departments working on the scene with patients and possibly crime scenes?
In a situation, that's a good question. In a situation where you have people who are injured and receiving medical care, I think, that's going to be a situation where you have a right to privacy that's going to compete with the right to videotape. If you have like an injured person, you can't walk up and just take pictures. I think that's going to be a situation where the fire professionals would be within their rights to restrict access. The other thing would be, if you're trying to deal with a fire situation and you've got a work scene there where you're trying to deal with an ongoing situation, I believe you could set up, barriers to keep people out of a situation for the safety of themselves and the firefighters. The other question, what was the other question with respect to
crime scenes?
Crime scenes. With a crime scene, you're also going to have the ability to rope off the area and limit public access to that. If it's an area that people have a right to be in, they can videotape there. But I believe because of the necessity of, investigation, preserving evidence, and so forth, and for that matter, there's some things that you don't want to necessarily have the public have the ability to photograph. I believe you're going to have a certain amount of discretion to limit public access, but you've got to limit the public access so that everybody's treated the same once a crime has already been committed. Not when somebody is in the process of being arrested, because you see so many situations that are depicted on the news where people have used videotape of public interactions with police, and I don't think that's going to receive any kind of protection. But if it's actually blocking off an area so that police or fire can do their jobs to deal with a crime scene investigation or to put out a fire or deal with a situation or administer care, I think in any of those types of situations, that's going to be protected conduct. And I haven't thoroughly researched it, but I don't know of any cases that would hold that there's a right to be, there and impede, first responders in doing their jobs in that manner.
Do they have the same right to videotape other city personnel?
If they have a right to be there, they have a right to videotape. That's said another way, you have to treat the situation as if there was not a video camera or a phone that could videotape present.
Another question, what about a situation where the meeting is open to the public, then later closed due to executive session, but the media or First Amendment auditor refuses to leave the building during the executive session?
Well, that's an interesting question. You have a public meeting that can be, closed to the public for executive session. That's a non-public setting. If let's say the public body, there's two ways you can do that. One is the officials can leave the room and go to a smaller room, and then you can leave everyone in the main room. In that situation, it's easy to deal with. You just don't let them go into the separate area. If you have a situation where the public is asked to leave and the auditor then will no longer leave, then I believe they're in violation of, that's no longer a public area they have a right to be in, and the police would be within their rights to arrest for trespass or, disorderly conduct or some, state statute or local code ordinance that would make that kind of conduct illegal, because they would not have a right to be there at that point. The key is whether you have a right to be there or not. You don't have a right to be in an executive session. You do have a right to be in an open meeting. And if you have a right to be there, you can videotape. All right. This is all the police officers who are attending have seen this a number of times. Fourth Amendment to the U.S. Constitution. This is what you deal with on a daily basis, that prohibits unreasonable searches and seizures. And anyone who is arrested without probable cause has been the victim of an unreasonable seizure. Typically, as you know from criminal procedure, any warrant or any arrest without a warrant is deemed to be per se unreasonable unless it falls within one of the exceptions to the warrant requirement. But this is what you're going to deal with in these situations. Typically, you're going to be dealing with a warrantless arrest. One of the recommendations I will give you is, if you're going to make an arrest, do it with a warrant, videotape the conduct, take it to a judicial officer, because if you arrest based on a warrant where nothing was withheld from the neutral and detached judicial officer, then you're basically bulletproof in terms of a false arrest.
Hey, James, another question.
Yep.
If a department or office places a no recording allowed on doors or in certain locations, is that infringing on their rights?
The question is a no recording allowed going to infringe on their rights? And the answer is, in almost all situations, yes, that is going to infringe on their rights. If they have a right to be there, they have a right to videotape. That's the key. In a lot of these situations, you see the officers asking for identification, and this falls under the area of Terry stops. Terry stops is where you don't have probable cause to believe that a crime has been committed, but you have a reasonable articulable suspicion with specific facts. You can stop someone, but it has to be limited to the justification for intrusion based on an objective standard. Under a Terry stop, you cannot require identification unless there's reasonable suspicion that the person was engaged or has engaged in criminal activity. If somebody's actually engaged in a crime, it's one thing to ask for identification, but if they're just engaging in suspicious activity, like the kid that was in the first video, you cannot ask for identification there. Or like Mr. I think Mr. Gray and Mr. Dunn both were in situations where they didn't want to turn over their identification, and they hadn't engaged in separate criminal conduct, so it violated their Fourth Amendment rights to request identification in those situations. Persons temporarily detained for purposes of traffic stops, not in custody for purposes of Miranda. Therefore, Miranda warnings do not apply. And what Miranda would do is, if you have a custodial interrogation and you violate, the Miranda procedures, then it's not a constitutional violation, but it's presumed to be a constitutional violation for purposes of admission of the statements into evidence. So it's not actually a constitutional violation. It's a little bit of lawyer splitting hairs. It may not support a separate civil action, but the statements that were obtained would not be admissible into evidence if Miranda was not complied with. While police may request identification, the suspect may refuse to answer. This is one of these areas of the law that seems really odd to me, because if you're going to allow an officer to request identification, the natural thing is going to be to require identification, but the person can just turn around and walk away, and there's nothing you can do about it if that happens. Whether a Fourth Amendment seizure is implicated turns on whether the police officer's conduct would have communicated to a reasonable person the person was not free to decline the officer's request or otherwise terminate the encounter. Again, all of this is a consensual encounter between the police officer and the suspect. So let's talk about how to deal with these situations. What are the best practices? Well, members of the public taking pictures or videotaping must be treated exactly the same as if they were not engaging in either activity. So if somebody has a right to be somewhere, they have a right to videotape. So just let that sink in. It may seem counterintuitive, especially, we're coming up on the anniversary of 9/11. You remember after 9/11, you had a lot of people who walk around public buildings and look really suspicious, videotaping and doing this. There was a lot more sensitivity back then. That wouldn't quite trigger the alarms now that it would back then. But if somebody has a right to be somewhere, they have a right to videotape. Now, because they're there, you may not be able to request their identification, but you can take their picture. So you can preserve the evidence of somebody was somewhere being, suspicious. Like the kid in the video in the first situation. They could have let the kid go and taken his picture and said, well, if any of these houses are broken into, we're going to come and talk to you. But they couldn't require him to produce his identification, and they couldn't tell him he couldn't be there videotaping at that moment. If you come up on a First Amendment auditor and you realize what's going on, like all those situations where Mr. Gray, where he kept giving them an opportunity, or Mr. Dunn, where he kept giving them an opportunity, acknowledge their right to protected activity and wish them well. Once you do that, they're going to leave. If it's a situation where you have members of the public who have complained and want you to do something, tell the member of the public what's going on. Just say, this is what they're doing. They're engaging in expressive activity that's protected. I cannot do anything about them. If I leave them alone, they will go away, and the whole thing will just disappear in a very short time. Once the auditor's whole purpose is to get you to do something to violate their rights, and once they realize you're not going to do that, they will leave. Another thing you can do, and it's a spin on what I just said, you can turn the situation around. You can take a picture of them or say, hey, let's do a selfie together. Once they realize you're on to them, they're going to leave. If it's a situation where, you have somebody acting suspiciously, you can capture the auditor's image photographically with a body cam or cell phone, but beware, whatever you capture is going to be subject to the Open Records Act. Remember the one I showed you up in Madison? I showed you the hidden camera, but then a few days later, they went back and got the officer's body cam with an Open Records Act request, and that may end up on social media too. Don't take any actions to intimidate or coerce the person. Anything you do like that, they're going to try to turn that around to make it look like you're interfering with the exercise of their First Amendment rights. And of course, as I've said before, you cannot insist on identification to change the consensual nature of an encounter. Do not arrest the person unless they are engaging in a bona fide separate crime. Do not arrest somebody for engaging in expressive conduct. Don't obstruct, interfere, hinder the person's ability to videotape unless it puts the officer's safety, the safety of another person at risk. The person's entered a clearly marked crime scene. The person enters an area closed to public due to an ongoing emergency, or the person enters property not generally available to the public. In the last instance, trespasser warnings should first be given. So this goes back to some questions that were asked earlier, and those were actually really good questions because you're getting at the points I'm trying to make right now. Mark off the area, make sure there's a legitimate purpose to prohibit public access to the area, and then give warnings if you have to. If somebody's conduct is bordering on obstruction, respectfully and politely inform them their actions are interfering with the officer's performance of duties and ask them to move to a less intrusive position. when any of this is going on, it's actually good if you have the ability through a body cam or through a bystander to make sure that the interaction is recorded. And then before considering an enforcement action such as arrest, call a supervisor. Finally, all else fails, if somebody will not stop what they are doing and they're not hurting anybody, I mean literally hurting somebody, do not perform a custodial arrest. If you perform a custodial arrest, if it was unlawful, you can't undo that. You can't undo somebody whose rights and liberties have been restrained for any period of time. If there's a violation, issue a citation and let them continue what they're doing. If you issue a citation and you don't perform a custodial arrest, there has been no seizure of the person. And if someone looks at it later and determines, hey, this may have violated the First Amendment rights, you can just dismiss the charge, no harm done. They won't have standing to urge it in federal court. In the situation that I had with Jerry Weber many years ago, you had one of the GRMS cities had an English-only sign ordinance, and he represented someone who had put a foreign language sign up on their business. The citation was dismissed, and we ended up successfully having the federal case thrown out in the 11th Circuit Court of Appeals because the plaintiff no longer had standing. So if you just issue a citation and don't restrain the person or arrest the person, they won't have a false arrest claim. And that's what my last bullet point says. I went over, but I hope it was useful to all of you. Do you have any more questions, Dan? Anything else come through?
Yeah, one person here, the cases that have been reviewed thus far take into account actual public access areas. What about a prison where the entity of the property, entirety of the property is behind a guard line or labeled as no public access?
In no public access areas, there is no public access and there'll be no right to be there to videotape. So that's in a prison situation or a school where you've got security issues and, you know, you've got a whole host of considerations there. Or, you know, if it's an area where, you know, in the office part of a city where you've got, you know, sensitive information sitting around, you've got, you know, stuff that's not open to the public, you can put restrictions on people going back to those areas. But if they don't have a right to be there, they don't have a right to videotape. And if they don't have a right to be there, they're going to be in violation of, you know, probably some kind of public trespass, obstruction, maybe disorderly conduct. You probably could find several, you know, criminal charges under Georgia law or a local ordinance to go under in those situations.
Here's another question. How does the First Amendment freedom of speech and the freedom of assembly and the Fourth Amendment apply to offenders in correctional institutions?
Wow, that is a that is an interesting question. I've got to think about that for a second. You're certainly not going to have, you know, because you're in a correctional institution, the officials who are charged with running that have a completely different, you know, set of considerations in terms of maintaining order, preventing people from, you know, doing things or coming up with, you know, plans and things like that. They shouldn't. You're not going to have a right to get, because the people aren't there of their own free will. So there's not going to be a right to videotape in that situation. And in fairness, most of my career has been representing cities and police officers, and most of my work has been on the city side. The counties generally run jails, and, you know, my opinions about that are going to be based primarily on, you know, the way I see the interest involved here. But I would defer to somebody who's done a lot more work on the county side, representing jails, dealing with, inmate issues. But in my opinion, there would be a much more limited right to free expression and free speech inside of a jail population.
So James, I have a few questions myself. So
Okay.
just from my experience, I know I went to New York City on 1999 ball drop to turn 2000. And in that particular case, unless you were in the cages, you cannot stand on the sidewalk. You had to continually move, or they would charge you with louder, whatever. They would loitering, yes. So what about loitering? Is that a consideration? Can you keep people moving for public safety? Because if people start to assemble and block a sidewalk.
Well, Georgia has a specific statute that you actually asked me about. Somebody had a question about, when you're dealing with prisoners, there is a Georgia statute that prohibits, people from loitering and hanging around once officers have asked them to move on. In a situation like that, anytime you're dealing with inmates, people in custody, you have security concerns. You're dealing with school students, that would be the same. In a situation like, people on the street in, New Year's Eve in New York City, you may have security concerns that would allow them to do that. I don't think if you just had a no loitering statute where people can't sit on the park bench all day, I don't think that would be constitutional. But I think if you had some sort of overriding concern so that there was a significant government interest in keeping people moving, you probably could get away with that. Like in a New York Times Square New Year's Eve situation, you may have a situation like that where you do have security concerns and you don't want people just hanging around. But that's
what about situations where, again, in the news that you'll hear about protesters and they have designated areas within a committee or a community for protesting?
If there's a designated area, I think that's okay, especially, we had a situation a few years ago where down in the city of Noonan, we had the white supremacists show up, and I think maybe I don't know if they called it Black Lives Matter then, but a group like that showed up, and there was a lot of concern about violence, and the city had allowed these groups to come in and counter protest because of their First Amendment rights. And the way they dealt with it was by separating them. When you have a situation like that, and I think we've treated that as a model for other cities and city attorneys on how to deal with that. When you have a situation like that that really threatens violence, threatens a breach of the peace like that, I think if you have a designated area where you put people so they can protest over here, as long as you're treating everybody the same and you're not really impeding their right to protest, I don't believe that would be a problem. Because again, it all comes back to the, how reasonable is the restriction and how important is the government interest involved? Because in all these situations, it's a balancing contest. And if you're going to restrict somebody's right to protest or First Amendment, expression, you got to have a really significant government interest to do that. And I think in a situation like that, where you could have violence break out, you would have more discretion, but you cannot tell people they just can't protest. I mean, we saw this after the George Floyd riots around Atlanta. I mean, I don't think, if people can't block city streets, but if they want to stand on the sidewalk and peacefully protest, you need to do that. And to an extent, I think you may be called upon to make an area where people can engage in expressive conduct where they're not going to disrupt public order.
And then my last question, what's the line between harassment and legality? So again, if you're using vulgarity, if you're using, if you're, you know, up in somebody's face, if you're whatever, is there a line there?
Dan, you would not believe what passes constitutional muster. There's a case, there's a famous Supreme Court case where the guy shows up at like a public meeting. It may have been at the courthouse with a jacket on. It's from like the 60s. It says "fuck the draft" on it. And the Supreme Court has said that is protected expression. It's got to be in one of the categories. And they say, you know, like you cannot yell, you know, fire in a crowded theater. It's got to be engaging someone to engage in a crime. It's got to be so bad that it crosses that line into obscenity. Pretty much any kind of expression, verbal expression is not going to do that. It would take something like something that goes beyond basic pornography, not to pass constitutional muster. You cannot threaten an imminent breach of the peace. You know, you cannot threaten someone into a fight. If you engage in fighting words, you know, that can be a crime, but it's got to be at a pretty significant level before you do that. And my advice would be, if you have the flexibility to do it, and it's one of those situations where it may be questionable, I would, you know, take the information down, put it in a warrant application, take it down to a judicial officer and have an arrest warrant issue, because if you do that, it's going to be fine. If you arrest somebody on the spot, it may be determined to be fine after the fact, but then again, it may not, because there's a lot of judgment being exercised in these situations, and you know, you've got emotion that's coming into play. Some of this stuff is not clear. If you and I sit in a comfortable room today and talk about it and have the benefit of time and legal training to do that, you know, if you're a police officer out on the street trying to deal with a situation that's unfolding right in front of you, it's not nearly so easy. So I don't mean to sound like any of this is easy, but so if you have to make a custodial arrest, you know, to maintain public order, or because you've had a separate crime that's not you know, in your presence, do that. But if it's something where it's simply, you know, this person said this to this other person, and I think that crossed the line into fighting words, go get a warrant before you charge them, and let a judge make that determination. Because once a judge takes all the facts into account and issues the arrest warrant, you cannot have a false arrest claim against you. That will not survive if the person, even if the criminal charges are ultimately dismissed because there was a warrant, they will not be able to sue you for false arrest or malicious prosecution.
Very good. Any other questions out there? Well, James, thank you so much. Great job. A lot of great information. Really, really appreciate it. And again, as we do with all of our webinars, I will be recording this. I will be editing it a little bit and then sending it out for your review and or re-review for anybody that registered for this particular training. So thank you so much, James. You have a good rest of the day. Everybody else, thank you for participating, and we will all talk later.
All right. Thanks, everyone.